Georgia attorney and Trump supporter Lin Wood has had yet another election lawsuit thrown out in the state of Georgia, although this time it was not about the 2020 presidential election, but rather the upcoming Senate runoff election in Georgia that will take place on January 5th. And the reasons for this dismissal make this whole thing extra special. Okay? Are you ready for this? In the 2020 election lawsuits, one of the big complaints about these challenges to what was happening over absentee ballots. And this is the important thing. The challenge is over the application of Georgia law around absentee ballots and the risks for voter fraud that come from that. This is not necessarily a lawsuit about fraud that has occurred. In fact, it can't have occurred yet because the election did not occur in the Georgia runoff suit. But when the application of Georgia law was challenged following the 2020 presidential election, it was dismissed as untimely. Most importantly, too late. They said you needed to challenge these processes prior to the election taking place. We've seen this in Wisconsin, Pennsylvania, Michigan. We've seen it all over the place, the same types of dismissals. You can't do this based on what already occurred. It's too late. Well, now Lin Wood has challenged the election process prior to its implementation. And what did the judge say? It's too early. I wish I were kidding, folks. I wish I were joking, but the judge has dismissed this, and you can see right here in the subheadlines, judge calls lawsuit over ballots astonishingly speculative. Okay, it is speculative. It can't be anything other than speculative because it hasn't occurred yet. And sure, there's a possibility that they won't implement the law that they've promised to implement. They've demonstrated that they implemented it back in the 2020 presidential election. They're going to follow the same processes in this one, but I guess maybe they won't. All right, I'm going to link this article in the description so you guys can read it. I'm going to link Lin Wood's tweet in the description so you can check that out. And his tweet has a link to the actual opinion from the judge, which is 20 pages long. And we're not going to look at that full opinion, but we are going to read one page of that opinion, really one paragraph of it, to demonstrate just how ludicrous these election lawsuit decisions have been and how far across the board they have been dismissed by conflicting reasons. That is leading to the frustration of normal people out there looking at this going, how in the heck can we have any challenge to any of these things if judges say that you can't do it beforehand, you can't do it afterwards, and you can't do it during? But let's take a look at Lin Wood's tweet right here. It says, Federal Judge Timothy C. Batten Sr. dismissed my Georgia lawsuit this morning at 11:12 a.m. after I filed 270 pages of fraud evidence yesterday at 6 p.m. 20-page order. He must have been working on order for days, or he is quicker than the FBI in Nashville, referencing the recent bombing attack in Nashville. Okay, here is the one paragraph of the order, and that is where we're going to end after that. This is on page 14. It's the second paragraph. However, even taking his statements as true, Wood's allegations show only the, quote, possibility of future injury based on a series of events which falls short of the requirement to establish a concrete injury. That quote is from Donald J. Trump for President versus Bakvar. That's the Pennsylvania federal suit filed by Donald Trump against the Secretary of State of Pennsylvania. Importantly, though, it is not the one you're thinking of, which was filed after the election. This is the pre-election lawsuit where Donald Trump did challenge the application of absentee ballots in Pennsylvania. And what is the explanation of this suit that's provided? Rejecting a theory of future harm where the increased susceptibility to fraud and ballot destruction is based solely on a chain of unknown events that may never come to pass. What happened, though, when some events did come to pass up in Pennsylvania, as alleged by Donald Trump and others, that was resulting from the improper application of Pennsylvania laws? They dismissed it because they said it was too late. They said you can't do it now. So you can't challenge it before, you can't challenge it after. The reality about this is standing, latches, timeliness, mootness, ripeness, these are doctrines that the court has used to avoid very difficult questions, and that is not changing anytime soon in relation to the 2020 election or apparently the Georgia runoff election. And we can suspect that if that election is at all close, there will be challenges that follow it, and the courts will throw out those challenges as well, stating that they are not timely because they are too late. And that is where the law around elections is in 2020, folks. All right, leave a comment below. Let me know what you think. Do you think I'm crazy? Do you think the judge is crazy? Do you think Lin Wood's crazy? Do you think everybody's crazy? Let's have a discussion about it. Talk to you guys soon. Peace. Peace.